Вітаю, друзі, дякую за вашу увагу до нашої події.
Thank you for your attendance at the event dedicated to illustration as a tool in aiding recovery of Ukraine. The survey and this conference has been supported by the International Renaissance Foundation. After the outbreak of the full-scale invasion, many wanted to know what measures could be taken in order to mitigate the consequences. Many experts back then already predicted a range of consequences that became increasingly evident after the full-scale invasion. As there is essentially, we have been talking how we can counter the influence of the Russian Federation, including recruitment of Ukrainians to work in Russian occupying authorities, and how we can counter impact on the people that are residing in the temporarily occupied territories. The study we've undertaken shows how the government may counter these impacts, how the trust in government institutions can be renewed and enhanced. We are happy to have Daris Ridova, Azon, co-author of the brief we'll be discussing today, Maxim Chadalashvili, 5 a.m., Alexander Kluzhev, an expert in electoral legislation, and Tamila Tasheva is on her way, People's Deputy of Ukraine, member of the Ukrainian Parliament. My first question I would like to confront Olga with, and it is related to the activities of the representative office in Crimea. It was the platform where multiple activities have been undertaken. So what is the role of the representative office is concerned, and what other things the representative office is involved in? Hello, thank you. It's a very important topic, and I appreciate the opportunity to discuss it now in order to identify ways in which our state can overcome the consequences of the armed conflict raging in Ukraine since 2014. The representation is a government authority who is in charge of developing approaches to transitional justice, amending Ukrainian legislation, making proposals as to how the government may address the challenges arising from the occupation. We started the work in this area even before the full-scale invasion on a smaller scale. However, after 2024, being aware that the challenges Ukraine started to face after the annexation of Crimea and occupation of certain regions of Ukraine, we, as instructed by the president, started developing a vision of how the government might reruin its control in the occupied territories, how it will go about protecting the interests of the citizens who had to reside in occupation. It is clear that we created a work group that included some panelists of today, independent experts, human rights defenders, who all contributed their proposals, their critical remarks, which is quite logical. that helped develop a range of tentative solutions that might be applied to people who had to work in the temporarily occupied territories. Lustration is readily associated with the accountability for collaborationism, but they are different things. Justice does not necessarily mean bringing to criminal account. And I would like to recall that our criminal code was amended to include 2 articles incriminating collaborationists, and these articles defined ways in which people collaborating with the occupying authorities could be brought to account. And now, if we look at the situation in the Crimea, occupied 11 years ago, we see that almost 200,000 people could be brought to account under these statutes. We have no complete stats, for instance, on the relevant number of positions held by different individuals in Crimea, so this is just an estimate, and we all could understand, including that the society demands justice, but is not ready to wish that everyone that maintained any contact with the occupying administrations be held accountable. So our proposals contain elements of transitional justice. Illustration is part of it, but not only that, and it cannot be considered in separation from others. Illustration is an element that can be considered by the state in order to renew trust in the government authorities to be created in the liberated territories, because almost 50,000 people have to be put in place in those authorities, 16,000 of which are supposed to be government civil servants of Ukraine. So solutions have to be applied not only to the occupied territories. In discussions with the colleagues, we also considered which territories could be subject to illustrations. At any rate, we have 2 draft pieces of regulations that reflect the position of the government on lustration, vetting the persons who indeed collaborated with the occupying authorities, but their violations were not of the nature of the criminal nature. The mechanisms once created was revised in 2023, and Provision 18 of this document instructs the government to develop mechanisms that would help reinstate trust in government authorities. Also, I'd like to recall the resolution of the Parliament of Ukraine adopted on the eve of the Crimea platform, in which it is clearly stated that citizens of Ukraine may not be prosecuted or otherwise maltreated for residing in the occupied territories. At the same time, people incriminated or implicated in war crimes must. At this point in time, we have government decision, the vector set by the Parliament of Ukraine. With other colleagues, we continue working on expounding on some other specific measures. I mentioned lustration, but we also have been thinking of how government institutions have to be reinstated. What is the effect of the documents issued by the occupying territories? They are not valid, but they have effect on the lives of citizens. Why I'm talking about that, because speaking of transitional justice and overcoming the consequences of the armed conflict, we cannot separate one element from another. Lustration is what will help Ukraine attain the necessary level of trust and will meet the demand of the public, of the society for justice. Thank you very much. Once again, I would like to emphasize the role played by the representative office in the Crimea. Decisions developed by it can equally apply to overcoming the consequences of occupation in other territories. The brief, the concept paper is the product of those initial steps, looking at lustration as one of the important elements of the process. The drafting of the brief was started almost 2 years ago, and at that time it was entitled "Whether Can Lustration Be an Element in Overcoming the Consequences of Aggression?" Today, the document reads differently, how lustration can be. So, Dasha, my question to you, how do you think lustration can be a tool in overcoming the consequences? By the way, lustration isn't a new word in Ukraine. We had experience of lustration after 2014. Is it going to be the same lustration as then or a different one? Thank you, Alona, for the question. Well, will it be different? Yes, it will. It has to be different. Unfortunately, it'll have to be different from what was never done during the initial stages of lustration 2014. Essentially, the goal of lustration will be different, whereas lustration that was officially completed last year aimed at removing people implicated in corrupt activities associated with the reign of Yanukovych. These procedures didn't mean to remove from power people who could have been implicated in collaborating with the Russian Federation. So the document that we are presenting today proposes an architecture of lustration measures called upon to help rebuild trust in the government authorities by preventing participation of persons who might have compromised themselves through collaborating with the Russian Federation. I'll say a few words about the foundational principles of the document. In working on it, we were in constant consultation with representatives of the civil society and different government authorities, the Parliament of Ukraine, international experts, while seeking advice on specific elements. We held consultations with local communities. In the years leading to the full-scale invasion, rating group carried out annual surveys of the population in respect of different aspects of justice in mitigating the consequences of war. And we also ask them to include questions related to lustration. Inter alia, we wanted to see if the consensus in the society is likely to change. In the past years, however, some negative trends could have been observed with regard to steps that could prevent participation of persons who may have compromised themselves outside of the criminal process. Yet another pillar, so to speak, we relied on working on this document was the case law of the European Court of Human Rights, which has to be studied diligently in order to avoid mistakes in illustration, as well as the UN and PASI. And, of course, our own experience of lustration of 2014 as enforcement of the law of Ukraine on rebuilding trust in the government authorities. So we proposed architecture proceeding from these various reviews we've taken. I'll also say a few words about issues that are explored in this. The first key element to be heeded is that illustration has to be personal, not collective. In other words, in spite of what many people wanted to see and that transpired during our various meetings, to prohibit representatives of any political party or all citizens who received Russian passports in the occupied territories is likely to be unacceptable in the light of international approaches and potential consequences of such lustration. Second element, lustration procedures should contain a complaint procedure and appeal procedure. The architecture of lustration must be set forth in law because it may lead to the restriction of the right. Limitations must be of temporary rather than permanent nature, and the vetting criteria in law have to be universal. Some expect that lustration will only apply to deoccupied territories, which is not the case. If lustration is adopted by law, it'll be universally replicable in all territories of Ukraine, including the government control areas of Ukraine. The architecture of lustration may take the form of an administrative mechanism, such as submitting declarations that is to be made by a candidate for positions, together with some other support documents required to be a contender for a position in the government. Now, who lustration will apply to continue my discussion of the architecture? Olga has already mentioned, and I reconfirm that the proposals we will have to lead to changes in the legislation of Ukraine, criminal legislation, inter alia, that in some respects enforcement of those provisions doesn't comply with the international humanitarian standards. In other words, changes to sum it up. And the proposals we proposed and the criteria provide for the application of limitations to persons who held specific positions in the occupied territories or carried out some functions or were members of the Russian political parties, members of the electoral committees, worked in the media controlled by the Russian Federation. So the list is fairly long. One of the criteria is engaging in business activities in the territories of the Russian Federation or paying taxes in the territory of the Russian Federation by citizens who apply for certain positions. The brief also contains a pointer to the list of positions. In summary, there are 4 key categories: positions in public authorities, including law enforcement agencies, where a person implicated in collaboration with the Russian Federation may create significant risks. Another category is those who are involved in decision making, such as Prime Minister, Deputy Prime Ministers, grade A and some grade B categories in civil service, but this is open to discussion clearly amongst the groups to which lustration may apply. We suggest that some professionals be included. Well, the government may not. I'm talking about lawyers, media communities, notaries, banks. The 4th category are elected officials, such as candidates for the President of Ukraine, candidates for members of the Ukrainian Parliament. Potentially, lustration during elections is probably the most likely way to escalate demand for lustration, and I will not go into detail explaining how this will be different from lustration as applied to the candidates for government positions or civil service position, but generally speaking, declaring connection with the Russian Federation may not be grounds for refusing to register the candidate, but it is grounds upon which voters should be widely informed of this connection, because concealing such connection may pose clear risks. And the procedure. Well, there is not one clear procedure, rather a range of ways in which lustration can be enforced. What is essential that the body responsible for lustration has to be collegiate. It may be a commission under the Central Executive Authority, including mandatorily representatives of the civil society, or it may be a collegial body under the National Institute of Memory. There are precedents around the world, or generally speaking, the society tends to prefer a wholly new body to enforce lustration rather than vesting this authority in an existing body, which testifies to the lack of trust in we also need to understand that the mechanism of lustration that we propose won't be implemented in the vacuum, so to speak. It is obvious that certain lustration mechanisms or procedures already apply, even though we don't call them such. Professional communities, lawyers, judges, for instance, the High Council of Justice approved judges' integrity criteria where references made to the connections with the occupied territories. Some representatives of the professional community criticize a mission against lawyers who are already active in the occupied territories. Currently, 2 drafts are in the parliament that look at prohibiting participation in public life in respect of the representatives of certain political forces. So critical balance can hardly be maintained given this inconsistency. A balance between the necessity to reintroduce this measure, but on the other hand, promote reintegration, which means we cannot just refuse members of the public that resided in the occupied territories participation in the public administration. So there is a risk of marginalizing the people who are found to have been in some connection with the occupying authorities or the Russian Federation. Thank you. Tamila Tasheva has just joined us. We promised you'd do it. I know that it wasn't easy because the parliament is in session. Now, my next question is whether the society perceives lustration as something proper, given the prior experience of lustration. So let me ask Maxim if there is still a demand for lustration. And second, lustration is not just about removing certain persons from the government in order to reinstate trust in the government, but it also relates to the memory policies. Do you not think that lustration may help us build a better policy of memory in the future? Thank you. If I may, I would like to refer to my presentation insofar as it would be hard for me to speak about trends without showing them visually. Well, illustration and historic memory are like symbiotes. If we recall discussions around lustration, we'll have to recognize that they always arose in critical times as a response to some critical situations that the society and nation faced. The first proposals were made in order to prevent participation of those who could have been involved in security bodies, law enforcement bodies of the former Soviet Union from participation in public life. As a result, Ukrainian Institute of National Memory arose. It made some attempts to extend lustration to all the elements of the government. This permanent substitution is a permanent feature, and we can try and combine both approaches. In the context of Ukraine, different modalities have already been tested, developed, and it is important not only to incorporate international and national practice, but also be cognizant of the national consensus. Lustration doesn't come to the forefront when everything's fine. No. Lustration is a response to what could have happened in the past with a view to preventing certain risks to arise in the future. I tried in my presentation to refer to different studies. The lion's share of the respondents were polled in 2014, no earlier than that. But after the Revolution of Dignity, which revolutionized processes mentioned by Daria and triggered the development of certain mechanisms, including illustrations, in 2014, showed that lustration must be one of the top 5 measures to be taken by the government next year. 2019 also was the year when lustration was mentioned amongst top reforms to be undertaken. So, irrespective of whether any instruments have been priorly tested or not, trials held, drafts adopted as laws, the demand for amplifying instruments of justice has always been present. If we specifically ask a question in our most recent survey of March 2025, to identify whether their awareness was pretty high, people mentioned that almost 2/3 have heard about lustration, have certain knowledge of lustration, and their attitude was quite positive. Experts often discuss whether lustration has been effective or not, but for general public, this practice is not somewhere in the blind spot or a practice that was frustrated or disoriented. 2 more studies, comparative studies, July 2024, civilian population, and August of the members of the military. Rating did this on a commission from Lago, which is in the business of carrying out comprehensive studies of the system of justice. We in fact compared the findings of 2 studies and identified a difference in responses of civilians and those who have had combat experience, served in the armed forces. So when we asked whether official justice need to be amplified by supplementary mechanisms such as lustration, almost 80% of both civilians and members of the military approved of this practice. Another element of the national consensus is that lustration, demand for lustration is throughout entire Ukraine, not in some specific territories. Moreover, people would vote for the permanent nature of lustration, whereas there were others who opposed this decision. Additionally, demand was quite high for certain hybrid mechanisms involving international actors, UN. Well, Ukraine seems to be permanently to have permanent proclivity for hybrid mechanisms. And the third dimension, you started with the question of whether illustration can be combined with building a policy of memory. Illustration isn't the same as it used to be. Earlier on, it was about preventing penetration of the government mechanisms with those who supported Yanukovych. Now, illustration seems to be gaining an additional aspect of rebuilding trust in government authorities. The mills of justice go slow, and therefore certain legal certainty may be provided through illustration. What's important, the responses didn't differ much across the regions, with the exception of the young people. If we speak about certain problems, one of the key issues is, well, on one hand, a fairly high level of support for extrajudicial mechanisms, and second, the practice. You may recall in 2014, 2015, and currently the illustration through the so-called dust bins or garbage containers. It was a very popular measure in 2014. On the left-hand side, you see findings of a survey carried out by the Institute of Psychology. Almost 45% responded positively to this type of lustration. We wanted to ask if this certain kind of lynch court justice would resonate with the people if illustration fails. If traditional, the dynamics will depend on the attitude of the general public. Currently, we can see that the trend has preserved. Thank you, Maxim. It, in fact, was scary to raise lustration after 2014, but the rating service showed that the general public is still quite positive about lustration, and the instruments of criminal justice do not seem the only tools to be made avail of when mitigation of consequences of an armed conflict are concerned. Daria said that first post-war elections will inevitably bring to the forefront the issue of preventing unwanted candidates, electoral lustration or lustration of electoral offices may be based on clearer international principles, and probably our partners will emphasize them. And I would therefore like to ask Alexander, can we expect lively discussions? Are there standards that we can refer to when deciding on what kind of lustration can be put in place? And thank you for your attention, for your question. Yes, your questions have always been tricky. I'll start, however, with a statement that protection of democratic institutions, including elections, is a legitimate task of the state, as shown in multiple resolutions of the European Parliament, Parliamentary Assembly of the Council of Europe, the Venice Commission, and other European institutions. It means that the Ukrainian government not only may but should look for mechanisms that would prevent compromises in elections. However, it is key to strike a balance between the need to protect democratic institutions and the need and necessity to prevent deterioration of the democratic standards of elections. For any nation, including Ukraine as a democratic one, it's not an easy task, and this is the burden that the Ukrainian Parliament will have to carry. Thank you, Tamila, for joining us. The Parliament of Ukraine is operational. It's been democratically elected, and it is in a position to make a final say in how Ukraine will implement the pan-European aspiration for striking this balance between democratic institutions. The discussions are more than timely insofar as currently Europe is trying to find answers to the question how European institutions and practices are likely to protect elections against adversarial or malicious intentions, and we are contributing to this discussion. I may sound a bit idealistic, but I would really love to see Ukraine as a full-fledged member of this discussion, and all of us have to facilitate this discussion. When I mentioned that it is the heavy burden that the Ukrainian Parliament will carry, I wanted to say that introducing certain barriers should emanate from the broad-based discussions initiated in the Ukrainian society and in the discussions of how we are going to protect our democratic institutions, because the Parliament will inform its legitimate decision on the outcomes of this discussions. The Parliament will make its best effort to remove persons who compromise themselves from having any influence on the electoral processes. Why it is so difficult to strike a good balance. For any nation, it is important that any measures taken with a legitimate aim should comply with the legislation of the country, and we have to make sure that the measures proposed are indeed aligned with the Constitution of Ukraine. The role of the Constitutional Court of Ukraine cannot be underestimated, as it is incumbent upon him to make a judgment on various initiatives. Yes, the Constitution contains a list of grounds upon which voting rights can be limited, but specific initiatives are subject to the Constitutional Court process, and we hope that it'll stand to its obligations, introducing new limitations on the suffrage, and depends on whether the outcomes of such limitations are commensurate with the risks arising from such limitations. If if investigation is pending, how can a person be limited in their electoral rights? It's always a difficult issue to consider, and the Ukraine will have to also see whether the risks are adequate to the dangers. Venice Commission, in some of its opinion, indicated that in certain circumstances it is better to limit the powers of an already elected official than to limit the rights of a person pending investigation and trial, because it may have an adversarial impact on the electoral process as a whole. So striking this balance is an important and very exacting task. Needless to say, speaking of the brief of the analytical paper, it does try to give its assessment of various measures proposed to protect certain electoral institutions. As it stands, the brief promotes the right of voters to base their choice upon fullest achievable information on a person's possible connection with the occupying authorities. In case a candidate provides false information, registration can be annulled. Again, if we look at international experience, we may find examples of democratic institutions protecting against malicious influence by broaden access to information and punishing failure to fully declare. Whether this model is sufficient to mitigate all consequences of the Russian aggression, I'd say no, but it's a good start to keep searching for viable solutions and to see how people are willing to declare their implication. So this generally seems to be aligned with good practices of protecting electoral institutions. Once again, I appreciate the opportunity to contribute to this important discussion, and I hold that it is just the beginning of such discussion, especially at the decision-making level, but it is based on some specific achievements. I may be a difference with some provisions found in the already registered draft laws, but it is important to broaden the horizon of this discussion. We as a democratic society are on the right track to finding optimal solutions that the government of Ukraine, that the Parliament of Ukraine may use in its decision making. Thank you very much for putting us in focus. Especially at the time when the country is affected by the intense hostilities. You were right by mentioning that the final say is with the Ukrainian parliament, and therefore I would once again like to compliment Tamila Tasheva coming here. The Ukrainian parliament will play a key role. Alexander mentioned discussions. Was he right? Is the parliament discusses lustration in the parliament, and those two draft laws Alexander mentioned, to my knowledge, they are the only laws related to measures to prevent contamination of elections by persons implicated in collaborationism. Hello, Alona, everyone. Olga Korishko, permanent representative, mentioned that. Indeed, the discussion was started at least in 2023 or even earlier in 2022 when the representative office was instructed by the president to develop a brief on what would have to be done after the occupation of the Crimean Peninsula. Later on, the brief was developed further on, and I still recall discussion on the premises of the parliament. Many parliamentary commission heads or deputies got engaged, and the issue of lustration was raised back then. So, to answer your question, indeed, discussion is going on. Not everything being discussed is publicly accessible, insofar as it contains loads of sensitive things that have to be discussed discreetly. And that's right, there are several draft laws. Most of them deal with limitations on electoral offices. Indeed, there's an opinion of the Venice Commission. We attended a high-level dialogue at Strasbourg and discussed it fairly hotly. My colleagues, so discussion is ongoing. It's also going on within the framework of our leading commission on government building, which will deal with first post-war elections, and it appears that the discussion testifies to the existence of a fairly high demand for justice post-war, and our society is well informed and pretty wise, in spite of the fact that representatives of government authorities or parliament may believe the public isn't at all inclined towards bringing punishment upon everyone. Experience of life in occupation back in 2014 was limited. Now the lived experience is in, well, millions of people. Even in Kiev region, there are people who have their own lived experience. Kharkiv, Kherson. So, on one hand, indeed, there's a demand for punishing those who collaborated patently. On the other hand, there is understanding of the fact that some people could not decline certain cooperation with the occupying authorities, and that's exactly what we say. Lustration isn't criminal in its nature. According to international standards, if we look at the matrix of transitional justice, it is in a different box, so to speak. It is introduced for the purpose of prevention rather than the purpose of prosecution and punishment. We understand, and I repeat, not every element of discussion, at least as far as the parliament is concerned, should be made public, but it is going on. Recently we attended, so to speak, confidential meeting between members of the parliament and experts of the civil society, at which at least some contents of the brief was presented, and you remember there were lots of questions raised. My colleagues from the parliament made their proposals that I believe will have to be accommodated in further discussions related to illustration, and this is probably it from me. Now, Maxim mentioned garbage can illustration. I would also like to recall that 2019 wasn't just an electoral revolution. It was, in a figure of speech, an electoral illustration that was brought to life to remove people who had worked for decades under different presidents and even regimes, more democratic or less democratic, from power. They were not elected as a result, at least en masse. Dmitro Kostyuk, my colleague, He's a young guy. He was 20 plus, and he beat Mr. Litvin, the former Speaker of the Ukrainian Parliament, person which is not free of controversy, but at any rate, people sought a fresh trend in the government. So you can call it electoral lustration. It means that there was demand, all service point to it. So I sincerely appreciate my cooperation with the colleagues with whom we had been working on various analytical papers. Well, I prefer the word vetting rather than illustration. So I do think that we have to continue along this track, sometimes not publicly, and I believe my word, am confident that there'll be a lot of MPs who have to be convinced of the necessity. This present convocation has been in place for more times than any previous convocation, but it's worked quite productively. Just look at the number of laws passed by the parliament from the time of elections, and even more so from the time of the full-scale invasion. Thank you. Thank you, Tamila. Thank you, colleagues. We have tried and outlined what needed to be pointed to in the context of working on this lustration mechanism. If there are any questions, I would like to ask my question. The brief is an expert product, not in terms of sources used. What comes next? What would you expect the government will do with it? And second, do you think it is something that needs to be done now or can be deferred until better time in the future, maybe until the time when the territories have been deoccupied? So two questions. Who wants to start? What next? I already mentioned the discussing expectations. Intuitively, I think that the most acute demand related to illustration will come at the time of the first post-war elections. The desire to prevent participation in the election of persons that pose risk to democratic institutions is pretty strong. We keep hearing about that in different situations. But on the flip side, it may lead to a temptation to introduce measures that might be unconstitutional, to decisions that so the same time The discussion focusing on the review of the electoral architecture post-war can help we need to will be taken care of in the architecture enacted as laws. Of course, key demands are on the parliament. No matter how we enshrine lustration with regard to government officials, this will have to be enshrined in law. And I expect that the discussion will go on not only in the parliament but in civil society. We see now that certain initiatives in professional communities such as the judiciary is already going on quite emotionally, maybe because of the desire to meet that demand of the society, but some of the findings our service bring is that the society's demand is not so much for punishment as it is for the prevention. Lawyers, judges, I already mentioned, have to be quite keen to maintain this discussion and help build broad-based international consensus built on best international practices and standards that have to be taken into account in proposing and enforcing limitations. Let me briefly add two things. If something that I started today's discussion, reintegration. It is held that reintegration, the time of reintegration is after the territories have been liberated, but this doesn't suit Ukraine in particular. It won't work in Ukraine. This is exactly why we, jointly with representatives of the government, civil society of Ukraine, are working on reintegration policies. Now, discussions have to be initiated, decisions have to be made, and institutions that have ownership will have to integrate powers and functions that can be exercised when circumstances are ripe. I mean, as Daria mentioned, in some professional communities, we see demand growing for more or less clear attitude to the people who stayed in the occupied territories or traveled to occupied territories. So when there is one consistent system, or at least a framework set forth by the government, it'll help avoid equivocality. So this must be clearly a clear position. But we try to resolve issues by legislating, right? But the practice has shown that laws first I determine a framework that is then fulfilled with regulations or secondary legislation. So aside from clearly clearly any legislative initiatives taken by the parliament will have to be implemented by the government. There are leading ministries involved in developing mechanisms of renewing the operation of the government authorities in the occupied territories, Ministry of Social Policy, multiple other stakeholders that are expected to contribute to the development of mechanisms of the transitional justice. Thank you. Thank you. If we don't stop and we don't working on the legislation to define post-war elections, protection of elections against malicious influence are on the table. After the full-scale invasion, the parliamentary committees and a broad range of civil society organizations started working on tentative solutions to prevent destructive influence of the aggressor state on elections. In 2022, there were proposals that had to do with the operation of the election commissions. These issues were on then gender in the Parliament of Ukraine. And in other words, the process is going on, and I, for one, believe, as subjectively as my opinion can be, that currently the fact that elections can be held now shouldn't be grounds for suspending work on post-war elections. But this is my subjective opinion, and we have to preserve this atmosphere in spite of all. But the roadmap of Euro integration, either directly or indirectly, have room for this discussion. For instance, Ukraine, within the framework of negotiations and the roadmap I mentioned, committed to accommodate post-war reality, underpinning the conduct of post-war elections, and inter alia, Ukraine undertook to properly inform voters on the course of campaigns. So the candidates are under the obligation to inform voters, and if the candidate fails to respect its commitment, certain sanctions are legitimate. So once again, as I already mentioned, the countries that cooperate with the European Union as candidate countries have to work on such solutions. So both legal and factual opportunities here. I fully share and endorse. We have to start working. Well, we have to continue working now, and the government, I assure you, has been working on it since 2022 on direct instructions of the CNC, the President of Ukraine, head of the government, Mr. Shmihal, Speaker of the Parliament. Had there been no consensus with regard to the need to develop this policy framework, we would have not been involved in discussions of that description. But once again, let me reiterate, there are some issues that may not be brought into the open. This doesn't mean that we cannot discuss them in specific conditions. Some sensitive issues, as you understand, need to be addressed in confidential circumstances, but our citizens living in all types of territories and even outside Ukraine maintain this demand for justice, and it has to be met. Thank you. The third solution is also a solution. We can contemplate certain documents that can become part of the reintegration processes, as well as the security measures taken by the nation in the face of the ongoing aggression. And once again, we need to learn the lessons. Back in 2014, there was no consensus, and we found a way to bypass it by undertaking certain research activities. It wasn't adequate to protect all the vulnerabilities in the emergent democracy, and as a result we had one revolution, then another revolution, and we all the illustration as a way to prevent participation of those involved in dealings with the ancien regimes were sought. Illustration in this case wouldn't be interpreted as supplementary. No, this will be regarded as a tool to provide more security, and I would echo Tamila, who was speaking about the 2019 experience, and at that time the elections were quite illegitimate, so that people could resort to this type of illustration by voting for new faces. Garbage cans is different type of illustration, so we illustration will protect the system. And the third aspect, we haven't discussed it, however, parliamentary elections might be a good tool to test different modalities. Given a limited number of hypothetical candidates, we can see which approaches are more effective to use them during local elections. So it's kind of a laboratory. We may, no matter what the conditions are, develop and test these mechanisms. And one other thing, I'm talking not about the discussion, but about nationwide processes. There are different registers, so probably we should think, look, we have a wealth of information about the war. This war is documented beyond comparison in digital format. So we might think of building a register or a range of registers that'll help meet the demands of justice or promote the right to truth and ultimately protect the government and the society against threats, the risk of being hacked, as well as and the third aspect, well, save money or resources, better yet. It's institutional resource, financial resource, and we will indeed be able to afford additional registers. The law enforcement is already overburdened. So these are things that make me think that it is quite timely and well, we have had a good discussion on various challenges faced by the society. And we seem to be of the same mind with regard to the lustration as part of the system. We can call it part of transitional justice, reintegration. You can give different names, but the nation should provide systemic response to the multiplicity of those challenges, and I think that this is now a position widely shared by members of the public and the government. Now we need to find a common platform for us to I once again compliment all participants of the discussion of how lustration can be a mechanism of overcoming the consequences of the armed aggressions. Mila Tasheva, Olga Kurishko, permanent representative, Alexander Kaluza, electoral reform expert and advisor to the Central Electoral Commission, Daria Sviridova, and Maxim Yagulashvili from 5 a.m. coalition. Thank you very much. The analytical brief is already posted on the ZMINA website. We are open to discussion regarding the content of this document, and of course are standing by to improve it in order to accommodate the